All right, well, good morning to everyone, and to our council. If you notice, there's a couple extra observers in the room, so this is our law day. Thank you for being part of this for us, and hope you all will stay around for questions afterward. And to our students and faculty, thank you for being here today, and I hope you enjoy and learn something from our experience. So we'll go ahead and call our first case. It's a consolidated case. 23-1545 and 23-1546. And counsel for the appellants, if you come forward.
All right. May it please the court.
Thank you, counsel. And counsel, if you could state your name, introduce yourself to the. Oh, okay. Oh, okay, 1 second. Go ahead, counsel. If you could introduce yourself and then let me know, counsel, how much time you would like to reserve for your rebuttal.
Thank you. May it please the court. My name is Matt Canigliaro. I'm with Carlton Fields, and I'm here today on behalf of the appellants in these cases. If I could save 5 minutes for rebuttal, all right, that would be greatly appreciated.
And counsel, before you start, I failed to make introductions of my colleagues. I'm Judge Jared Smith, and to my right is Judge Joshua Mines, and to my left is Judge Roger Ganem. And counsel, with that, 1 second, you may proceed.
Thank you. We are here appealing a summary judgment order for roughly $800,000 involving alleged fraudulent transfers. The order has been entered against both of the appellants, Mr. Chuck Thacker and Ms. Solani Thacker. This pair of appeals could perhaps be resolved very simply on the basic argument that the only ground stated in the order for granting summary judgment is that the motion was uncontested. And that is, as it turns out, entirely incorrect.
Counsel, as I read over everything for this case, I kept coming back to how the business court procedures themselves bear on that question, right? And interpreting what I view as, kind of two ambiguous or potentially in conflict provisions. So you have one provision that says failure to file a response may result, a timely response may result in the trial court considering it unopposed. You have another provision saying that a motion for summary judgment will be decided based on the evidence in the record and the arguments made at the summary judgment hearing. Now, the key arguments you presented on appeal were not presented in a timely written response. So I looked, they just weren't. You did make the arguments orally at the hearing. So if we think one of your arguments has merits, to me it comes down to how we interpret the Ninth Circuit business court procedures and the conflict, if there is one, between those two provisions. And frankly, it seems to me the most reasonable way to interpret those two provisions together is that the court considers arguments made at the hearing, assuming the motion is opposed, right? Assuming you place the motion in contention as opposed by filing a written response. And if you don't place the motion in contention, if you don't meet the deadline to say we oppose it by the failure to timely file a written response, then the trial court can treat it as unopposed. And you don't have new arguments on motions that have been submitted as unopposed. And in your brief, you address that. And I think you basically say that can't be right because the rules of civil procedure require a hearing. And so that interpretation would create a conflict with the rules of civil procedure, and the rules of civil procedure have to win. The problem is you can have a hearing on an uncontested motion. Courts do it all the time. The fact that you have to have a hearing does not mean a motion has been contested. So tell me where I'm going wrong on that.
Let me offer, first, thank you, Your Honor. Let me offer a few responses. First, getting straight to the issue of the hearing and what the case law requires. The case law says that the non-movement is entitled to a hearing. It would be empty if that hearing doesn't allow the non-movement to appear and argue in opposition to
What
the
if
motion.
one of the things you're arguing at the hearing was the response timely? Like there's all kinds of things you could have to argue at that hearing that don't conflict with the idea that the motion is unopposed, or that the trial court could, at the hearing, hear them out and say, listen, I hear what you said, you had your hearing, but you missed the deadline to place the motion in contention. Like that to me would be a hearing, you'd be heard, That doesn't change the fact that there's this provision that says to oppose the motion, to tell the court it's contested, you got a deadline, you got to file it. And I'm having trouble figuring out how your interpretation is set forth in your brief wouldn't completely nullify that provision. Like under your interpretation, a summary judgment motion, you could not file anything, and it would still be opposed. Even though the rules say, even though the procedures say, if you don't, it may be deemed unopposed.
Well, they say it may be deemed, but the rules 5.5 of the business court procedures expressly states that for motions for summary judgment, they will be decided on the papers and, I'm quoting, based on the arguments at the summary judgment hearing. So we have within the business court procedures themselves a provision that makes it clear the motion will be decided based on arguments made at the hearing. So
But counsel, just because it says based on arguments, it doesn't say that all arguments raised at the hearing will be deemed timely raised, or that it overcomes the lack of a timely submitted written response to a summary judgment motion. I understand that the language is in there. It says based on arguments, but it doesn't say that that all of a sudden all those arguments become timely just because they're making them at the court. That's my struggle. I'm having the same struggle Judge Mize is, at least with this, the way this language is written, trying to read these two provisions together.
I would encourage the court to step back and look at the larger picture that case law for decades has made clear, that the rules should be interpreted to reach the merits of the cases. Parties should ultimately be heard on their merits. They're not meant to be a trap or a trick. And here, if the business court procedures say that the motion will be decided based on arguments at the hearing, it's certainly a reasonable interpretation.
So counsel, answer my prior question. How does that not nullify the section saying if you don't file a response by the deadline, it's unopposed? How does your interpretation not completely eliminate that provision?
It's not eliminated at all. It says that, in fact, the exact language of 5.13 says the failure to file is a waiver of the right to file that memorandum. It doesn't say it is a,
No, but
you're deeming the motion
there's a
unopposed.
section, I don't know, was it 5.3 or 5.5?
I've got it in front of me. So,
Yeah.
counsel, it's the next sentence right after that. It's the failure to timely file a memorandum in opposition to a motion may result in the pending motion being considered and decided as an uncontested motion. So our focus is on the trial court's right to be able to treat it as an uncontested motion, not the first sentence of it being considered a waiver.
And Your Honor, that may play out that way for motions that are not summary judgment, but summary judgment motions are given particular attention in the business court procedures. And it's the language we were discussing earlier.
So I know there's some issues with your response, and you say you eventually filed it. Just assume there'd never been any response, all right? So Ninth Circuit Business Court, somebody files a motion for summary judgment, defendant files nothing and just shows up at the hearing. Your position is that's okay under the procedures? The trial court cannot say, hey, you didn't file anything?
Yes, Your Honor. That the trial court, if you appear at the hearing to oppose the motion, you should be heard to oppose the motion. Now, at the time of this hearing, we were under the former rule, so the language was different. But the case law has been quite clear that you are entitled to a hearing. You are entitled to speak to the motion. And I respectfully would disagree if the court's interpretation was that hearing would be limited to discussing whether you timely filed a response or not. The purpose of, and we've cited the case law saying, in fact, it's not just error to grant a summary judgment without a hearing. It's fundamental error. You don't even have to preserve the issue.
Counsel, take this. Say a defendant received a motion for summary judgment and appeared in a court file a document saying, I consent to the summary judgment. I don't oppose it. Okay? And defendant says, that's fraudulent. I didn't sign that. Somebody did that without my consent. I have no idea who filed that, right? Do you agree there'd be a factual dispute that the trial court would have to resolve, right? Like if the defendant signed that and stipulated entry of summary judgment, he'd be bound by it, right? Of course, if it's fraudulent and he didn't sign it, he wouldn't be bound by it. That'd be a factual question.
I expect so, Your Honor, yes.
Okay. So if you then had a hearing on the motion for summary judgment, I guess the defendant's entitled to, I guess the primary issue there would be, was it consented to? You'd still have a hearing, but there'd be there'd be a situation where the only thing you need to decide was the motion contested, right? Like, but I think the rules basically say by not filing a response, you consent, you deem it unopposed, right? I mean,
There we disagree, Your Honor. And I think the rule does not say that if you do not file a response, then the motion will be deemed unopposed.
But address the point there. There could certainly be situations in which you have a right to a hearing, right? And the hearing takes place where the primary issue at the hearing was the motion unopposed. Like the mere fact that the primary issue, because of the way the case played out, is whether a motion was opposed, doesn't mean you're not having a hearing. You're basically saying that that's not a real hearing. That the hearing means you get to make arguments on the merits, even if you didn't file a written response. And I just don't see why that's the case. I mean, there's many times you have hearings on unopposed motions, and you could certainly have a hearing where the main point of the hearing was there a stipulation, right?
I'm not going to disagree that you could have that hearing. You could certainly have that hearing. I will disagree, though, that the case law that requires there to be a hearing is solely so that the motion is called and someone could be there and you are not at that point allowed to oppose if you haven't filed something in opposition.
Well, hold on. In that situation with your fraudulent stipulation or your alleged fraudulent stipulation, that would in fact be the only issue the court addressed, right? And if it got to the hearing and said, listen, I find he signed it. He signed this. He wants to take it back now. He's lying. He signed it. There's a stipulation. He's bound by it. The court wouldn't then go on to address the merits, would they?
Under Your Honor's hypothetical, I don't believe so.
So how is this different? If the rules say that when you don't file a response within 30 days, it's deemed unopposed, that's just like if you sign something saying, I don't oppose it, I consent, I stipulate.
The actual language, Your Honor, is that it may be considered and decided as uncontested. And I'll suggest that considered and decided as uncontested is not language that applies here in the context of summary judgment. That's why there's another rule that addresses summary judgment arguments and says those motions will be decided also based on arguments at the hearing. Considered and decided as uncontested, I would suggest, is an opportunity for the court to not have a hearing at all and just simply rule on the motion. And that certainly happens on a regular basis, particularly in that court. But that's not what we have with summary judgments, and that's it. The purpose for the hearing, the purpose for the case law that says there must be a hearing, that it's fundamental error not to have a hearing, is to allow someone to come and speak to that motion. I appreciate that under the new rule, we actually have a response deadline and things are different. But prior to 1.510 changing as it did.
It seems like you're making a specific over the general argument, and that this, to the
Yes, Your
extent there's a conflict, that this provision specifically governs summary judgment.
Yes, Your Honor.
And doesn't the other provision specifically govern unopposed motions and the failure to file responses? Like, doesn't it kind of depend on how you define the specific and the general? Because, you could say that provision applies specifically to summary judgments, but this other provision applies specifically to motions where people don't file responses.
I would suggest, no, the more specific here is the summary judgment context, not the unopposed. Unopposed could happen in that context or others. In the context of summary judgment, though, it's Rule 5.5 that governs, and that's the rule that does say it will be decided based on, it lists the papers and then says also.
The 5.5, I think I have the numbers right, the section that says you have to file a response. Does anybody in the Ninth Circuit, has anyone in the Ninth Circuit ever interpreted that generally as not applying to summary judgments? Like for summary judgments, you don't need to file a response? Because it's that provision that makes you file a response to motions, right? And I was a judge in the Ninth Circuit. I'm not aware of anybody who ever said, well, no, 5.5 doesn't apply to summary judgments because that's a general rule and we have this more specific rule in summary judgments.
No, and I don't mean to suggest that the requirement of a response doesn't apply. I think the way to read it would be in the context of summary judgment, that that's when your written response is due. If you're going to file one, that's your due date in order to be timely.
So that section applies to 5.5 in terms of filing the response, but not in terms of what happens when you don't file a response?
In a word, yes, Your Honor.
Okay.
That if there's going to be basically you can't sandbag the other side under that rule with.
But isn't that what your client did? They showed up at the hearing with new arguments. That's like the definition of a sandbag, counsel.
Well, it is, but not. not a 20-page written memo that goes off on all sorts of different issues.
Well,
Here
hold
we
hold
had-
on. Nobody worries about somebody showing up at the hearing with a memo because the judge can't read the memo at the hearing. People worry about the people showing up and making new arguments, counsel. I mean, if you were to look up sandbag in Black's Law, I think it would look exactly like what your client did here. They had what you say are very strong arguments, right? You basically portray your arguments as a slam dunk, right? They didn't notify the other side. Then they showed up and surprised the trial judge. I'm trying to think of a more clear sandbag, and I can't think of one.
Well, you would be walking in with legions of case law that no one has gotten a chance to read yet or review. What we did was come to the hearing and make very basic arguments against what was said in the motion for summary judgment.
But at least if they showed up with the case law, you could pull out your laptop and try to look at it in real time. Your counsel didn't do any of that. They just showed up and orally said what you say are slam dunk arguments that completely defeat the motion for summary judgment and which they completely failed to disclose ahead of time. That seems to me to be the bigger sandbag than showing up with undisclosed case law.
Well, I appreciate that there's a concern there potentially, but ultimately, these rules should be interpreted in a manner that doesn't knock someone out of court, or in this case, result in an $800,000 summary judgment.
Counsel, if I may take you a little different direction. So it's just to clarify, the 5.5 is the rule that talks about under the business court procedures that if a hearing, that at a summary judgment hearing, if the hearing's not waived, that the court is to base the ruling on arguments at the summary judgment hearing, which you quoted. Later in the same rules, in 5.13, is the provision that Judge Mize has been speaking to, which says failure to timely file a memorandum in opposition to a motion may result in the pending motion being considered and decided as uncontested. But don't you think that the drafters of these rules for a rule that is after 5.5 would have said something like, except in situations of summary judgments? Because it seems to me that's your argument today, is you're saying that this rule 5.13, the last sentence, if I'm understanding you correctly, there's no way, based on what you're saying, this could ever apply in a summary judgment. Why wouldn't they have just said that if that's what they meant?
I'll suggest that it hasn't come up in this way, or it was believed to be clear enough that 5.5's language governed this aspect of summary judgment practice. Because to read it in a way that results in what's essentially a forfeiture, that if you do not file your written response by whatever date is set in 5.7, I think it says it's 30 days, that you've now forfeited your ability to oppose. You're entitled to a hearing at which you can't say
Don't
anything.
the rules set deadlines all the time to oppose things or waive your right to do so?
But
I
Your
mean, we
Honor,
do that all the time. The rules are replete with says like, if you want to oppose it, you have a right to do so, here's your deadline to do so.
we began this discussion saying there may be some ambiguity here. And I'll suggest that to the extent that's what we have, it should be read in the way that doesn't result in a forfeiture of your ability to oppose the motion.
If we read it your way, aren't we reading it that everybody in the Ninth Circuit can ignore the requirement to file an opposition to summary judgment and just show up at the hearing?
If what they're going to do is argue against the contents of the motion, not bring it up.
You agree, we rule for you. The rule in the Ninth Circuit is, because we're telling them how to interpret their own procedures, if you're in business court and you have a summary judgment filed against you, you do not need to file a response to preserve your arguments or to deem the motion opposed. You can wholly ignore the requirement to file a response and show up at the hearing. How do you think that's going to play out? A, it seems like that's what you're saying, so correct me if I'm wrong, and it seems like that's what you have to be saying. B, what are we doing at the Ninth Circuit?
Well, first, I'll suggest
You're a
that-
business litigator. Do you want to litigate the Ninth Circuit under that rule?
Well, to be honest, I think this happens every day all over the state. And I've seen it in my career, I've seen it many, many times all over the
Oh,
state,
but hold on.
that people don't file a response and come to the hearing and argue.
Isn't that type of practice exactly why they created business courts that needed a different level of practice?
That may be the case, Your Honor, in some respects. But here, that's part of why we have 5.5 saying what it says. And I'll suggest, if the court rules in our favor on this, that if the Ninth Circuit wants to clarify its business rules, that it certainly can do that.
Assuming the Ninth Circuit doesn't change them, Is there any way we can write an opinion for your client reversing that doesn't mean in the Ninth Circuit in business court, you cannot file a response and that's okay? That you cannot file a response to a summary judgment and you can just show up to your hearing and argue and everything you say is preserved? Is there any way to write an opinion for your client where that's not the outcome?
No, Your Honor, but I'll emphasize it's under the old rule. I don't know that it would be the same under the rule as it is now.
And counsel, I do want to ask you about that, because I think there's a couple other issues I want to get into, and you just hit one of them. Which rule are we under, based on this decision that the trial court made, was it decided under the old summary judgment rule, or was it decided under the new summary judgment rule?
Well, I'm glad Your Honor asked that. I probably should have transitioned to it earlier.
That's
in
what
this
we've been
discussion.
holding you on a different.
Yeah, it's not like we let you control
It's okay.
control the direction of the argument.
I appreciate that, Your Honor. But here's why it's important to look at that. The timing of this was a bit peculiar. The motion was filed before the change took effect. The hearing was held before the change took effect. By the time the hearing was held, now under the rule of civil procedure that says you're entitled to file your opposition materials up to 2 business days before the hearing, which by the way is where the true conflict would come from there too, with reading the business court practice procedures that way. Here we had an opposition that was filed 3 days before the hearing. The hearing is held. After the hearing is held, there's no ruling, and then May 1 or whatever the date was comes around, and the rule is now changed. The judge enters an order that says, we're now under the new rule. If anyone would like to file anything, go ahead and do so. Our side then refiles the same document that was filed 3 days before the hearing was held. So at least even in this case, the judge had recognized there has been a change in the rules, invited responses, and we refiled.
And your client filed one that was identical.
So we filed what was filed before the hearing. So
Does that count as filing a new response if you just refile the same document?
well, it certainly should count as the motion not being uncontested under any definition here of these circumstances. To say we didn't contest the motion when we filed something 3 days before the hearing, albeit untimely under the business court procedures, and then attended the argument, made a multitude of meritorious arguments why this summary judgment motion should not be granted. And then when the judge invited us to file anything else, the other side filed nothing. We refiled what we'd filed before. Under those circumstances, even putting aside some of this discussion we've had about how things could work on a hypothetical facts, here, this was contested.
So none of that changed the Ninth Circuit business court procedure. So in order to rule for you on that basis, well, we have to write some kind of opinion that basically said, well, they don't win under the new summary judgment rule per se, and they don't win under the Ninth Circuit procedures, but the trial court's order here kind of created this weird amorphous situation where they were entitled to kind of slip in between the two. Like how do we write an opinion based on that issue?
I think the easiest way for the court to address this would be to write an opinion that says that under these circumstances, under the old rule, where a filing was made before the hearing, where arguments were made at the hearing, and at the court's invitation, the prior filing was refiled, that it was error for the court to rule that this was uncontested.
Did you answer my question, though? Which version of the rule was this summary judgment motion decided under? Was it decided under the
I'm sorry if I didn't.
Yeah.
It's a bit of a hybrid. It was ultimately decided under the new rule, but events had already transpired that sort of matter when the new rule took
So if
effect.
it was decided under the new rule, then did the courts, in your opinion, did the court's ruling meet the standards of the new rule? Did the judgment actually meet the standards of the newly stated 1.1?
Well, the biggest standard from the new rule being that the court has to state its grounds, and the only ground being that it was uncontested. And that's part of why I started this, saying that the most simple way to reverse this is to recognize that the trial court erred in.
And would you say that that's insufficient under the new rule? We've got a business court procedure, and the business court procedure says if you don't timely file a response, the court may treat it as uncontested and rule accordingly. Is that not sufficient to meet the 1.510 standard that says The court has to state the reason on the record. Isn't that a reason on the record?
Absolutely, Your Honor. Maybe I misspoke. It satisfies the standard with respect to it being uncontested. We say that was error, but at least it meets the standard of giving a reason. What we've done in the briefing, both sides have gone past that to get to the merits of what was going on in the summary judgment, and none of that is in this order. So if the order is to be sort of defended or supported based on the merits or some set of arguments past the uncontested nature, then all of it fails under the rule because none of that's actually in the order. And as of May 1 of 2023, I'm forgetting, that was required.
Counsel, if we try to read these together, the business court procedures and the new summary judgment rule, is there a way that your client can prevail if, on the one hand, the trial court was authorized and did treat the motion as uncontested? Is there something in the summary judgment rule that nonetheless requires the trial court to take some look at the merits or exercise some, review of everything to make sure that, all the boxes are checked and this is a legitimate judgment based on what was, you've talked about the pleadings, you've talked about the claims in the summary judgment motion itself. Is there something in Rule 1.510 as it applied to this case that would require the trial court to still do some work even if it considered the motion uncontested?
Yes, Your Honor. I think that's part and parcel of our argument that it's why the case law requires a hearing. That the rule has been read for decades to require that the non-movement have the ability to appear in court and contest it, meaning that this is to be decided based on the actual.
I don't think it's what Judge Gammon, I think he's saying, assume that it was uncontested and that that was a correct finding that it was uncontested, just like if your client had signed a stipulation. Despite it being uncontested, did the trial court have some independent obligation to find an error or to not enter summary judgment based on some of these issues, despite it being in fact uncontested?
Absolutely.
And counsel, we recognize you're in your rebuttal. If you want to quickly answer that. So we can.
And I think the answer is yes, that under the text of the rule, the text says summary judgment may be entered if based, not the language, but based on the pleadings, there is no disputed issue of fact and the movement is entitled to judgment as a matter of law. And all of that, I would suggest, just sort of wraps together, that the court has to reach the merits of the motion. And that's part of why the hearing is required. And
in normal context, if a trial court erroneously enters something, so if someone stipulates to the entry of an order, and that order is later found to be erroneous, even if it was erroneous, have they preserved that error when they stipulated to the entry of the order?
if you've stipulated to entry.
In other words, even if the trial court had some obligation to look at it, if the motion was in fact uncontested, if you failed to place the motion in contention, have you preserved the error?
Here we have, in this case we have, because we did file before the hearing, we attended the hearing, we argued at the hearing, we filed after the hearing, we moved for reconsideration twice, there was a finality issue here, so we ended up with multiple reconsideration motions. Ultimately, it is, I will suggest, untoward and incorrect to find that this was uncontested. It was not. I will acknowledge that it could have been handled differently, but that shouldn't result in a forfeiture on the merits of the motion. And I think under the rule and the proper way to read both the rules of civil procedure and the Ninth Circuit Business Court procedures, that the court should have resolved this on its merits.
Okay.
If I can save the balance.
I will, Counsel.
Thank you.
Good morning.
Morning, Counsel.
John Bogdanoff, appearing on behalf of the Appellees.
Okay.
Two judges in this case found that the motion was uncontested, Judges Jordan and Judges Beamer. And the motion was uncontested under the business court rules. There's no doubt about that. A timely response was not filed. And so the judges were absolutely correct in making that determination. In addition, there was a hearing conducted here. This is not a situation where the defendants were not afforded a hearing. They had a hearing. The judge heard their arguments at the hearing and considered those arguments So they were afforded a hearing. This is no violation of due process. They had a hearing. They did not comply with the business court rules. That's clear. And the judges, both judges in the summary judgment, the first summary judgment was not final in nature because it didn't have language of finality. So a subsequent summary judgment, final in nature, was entered by Judge Beamer, which did have finality language. But both find that the judgment, that the motion was uncontested. And we believe that under a reading of the business rules, that's absolutely correct.
Counsel, if I may, so I'll ask you the same question I asked your opposing counsel. Was this summary judgment motion decided under the old version of the rules or the new version?
The new version.
Okay, so considering that, the new version of the rules, specifically 1.510A, states the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to summary judgment as a matter of law, the court shall state on the record the reasons for granting or denying the motion. How under the new 1.510 does your interpretation as you've put forward of the business court procedure rules of 5.13 survive based on that? Is there any such thing as an uncontested summary judgment based on the new 1.510 that specifically says it's got to state the reasons, the court has to put those reasons on the record?
The court did state the reason in the summary judgment order. It said it was uncontested and it cited to the business law rule.
But isn't there a requirement under the rule that the court at least in some fashion put within the order that there is, that this summary judgment is being granted based on there being no material questions of fact and showing that the movement is entitled to judgment as a matter of law? Where, other than just pointing to the business court procedure, where in the record, what record facts, what case law or statutory law does the court point to put within that order what would, I think, typically be compliance with 1.510? I mean, is there, and that's my question is there room for this whole concept of an uncontested summary judgment motion being granted uncontested? Is there really room for that under 1.510, the new version that we're under right now?
I think so, because by saying it's uncontested, that's acknowledging that what the motion consists of was not challenged, and therefore the language of the motion is deemed uncontested. So it essentially incorporates the motion.
But does the court not have an independent duty based on the new rule to see if there is in fact a basis under the law to grant it? That's my question to you. I mean, it seems to me that under 1.510A, at least on its face, and this may be the biggest question I'm struggling with, that it says the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. So doesn't the court have to at least look at that and make a judgment call? They can't just say, well, there was no opposition filed, so therefore you get the farm. Doesn't 1.510 seem to imply that they've got to at least look at the record and look at the law and then somehow put that reasoning into the actual order? Or am I missing something? Is there room under this rule for this concept of an uncontested summary judgment motion? You've asked for this, you get this, and the court can just blindly go ahead and enter it without really looking to see if there was a legal basis for it?
Well, I don't think the rule puts the burden on the trial judge to do the work of the defense in this case. I don't think that the judge has an obligation to pour through the motion given the fact it was uncontested and make an independent review when the defendant didn't make file a timely response to the motion.
Counsel, let me, I want to add to Judge Smith's question by pointing to 1.510E, which is where it says failing to properly support or address a fact. And as I read E, it says basically if a party, in this case the non-movement, fails to address the movement's facts as required by 1.510C, it says then that the trial court may, one thing it may do is consider the facts undisputed. But then it also says the trial court may, under E3, grant summary judgment if the motion and supporting materials, including the facts considered undisputed, show that the movement is entitled to it. I read this as specifically addressing the situation where the non-movement doesn't file anything to address the facts that are claimed to be undisputed by the movement. And the rule seems to authorize the judge to then go ahead and grant summary judgment if, even considering the facts undisputed, the other requirements for summary judgment are satisfied. And as I read that, I'm questioning, why doesn't that at least require the trial court to connect the dots from, and say, okay, the facts are undisputed. I still have to say, look at the pleading, look at the relief requested in the motion, and say, well, okay, as a matter of law, all the requirements are satisfied, assuming these facts are undisputed. I don't read that to say that the court can just say grant summary judgment, period, if the non-movement doesn't file any opposition. So doesn't the rule still require the trial court to do something to make sure that the dots are connected at least before entering summary judgment?
Well, first of all, E is discretionary with the court. The language you read and the case law indicates that the trial court has discretion to determine that if the facts have not been disputed, it can enter summary judgment. So the court has a lot of discretion under that provision, especially where there is no contesting of the facts. I think in this case, the court concluded, based on the violation of the rules, business court rules, that there was no impediment to entry of summary judgment. Now, does the rule require the court to go further? I don't see where it imposes an affirmative obligation on the court to then undertake an additional inquiry, which the defense did not provide any
If it did
objection or
impose that
guidance.
requirement, wouldn't that mean nobody could ever stipulate to entry of summary judgment?
If-
Right?
if
I mean,
the judge
that would
had-
mean that if, say there's 5 counts and, defendant moves for summary judgment on all 5, and plaintiff says, you know what, he's got me on counts 3 and 4, I stipulate, right? I'm going to contest counts 1, 2, 5. Under that reading of the rule, you couldn't do that, right? Because you'd have to have some independent obligation beyond the fact that the defendant has not opposed summary judgment. That would essentially remove the ability to stipulate, and there's lots of case law saying parties have the ability to stipulate things.
Right. I don't think the intent of the rule was to make it more difficult to obtain summary judgment. It seemed that the intent of the rule was to actually facilitate granting of summary judgment in appropriate cases. And by imposing upon a trial court the obligation to undertake additional inquiry after a party has been deemed not to contest the summary judgment, I just don't think that's reasonable, where the defense in this case hasn't done their job and has allowed the motion to appear before the court as an uncontested motion.
Well, counsel, what about a situation where, using your summary judgment motion as an example, I believe it's counts 11 and 12 in the complaint, in the fraudulent transfer complaint, address transfers between Mr. and Mrs. Thakkar. What if in the summary judgment motion it says we're basing this on counts 11 and 12, and we want recovery based on fraudulent transfers between Mr. Thakkar and one of his sons? In other words, a different party altogether from who is referenced in the particular counts of the complaint that you base your summary judgment motion on. Can the trial court still look at that and say, well, the other side didn't oppose it, but even though I can see that this motion is not based on the allegations of the complaint or even the same parties, I'm still going to enter summary judgment because no one told me not to?
Well, first of all, that's not our facts. We have the same 2 individuals, Mr. Thakkar and his wife, who are engaged in the fraudulent transfers. But I think in that case, yeah, it is a different case, and it does, we would have to impose a burden upon the trial judge to require the judge now to go through the complaint and to make a determination as to whether or not, the count is sufficient to grant summary judgment when the judge hasn't been given any guidance from the defense.
Also, isn't that because the trial judge in that case has to notice that that party hasn't been served and isn't part of the action? party who wasn't in the original complaint hasn't been served and brought within the jurisdiction of the court, and isn't within the jurisdiction of the court to oppose or consent to any motion because they're not there. I mean, isn't that more in the vein of when trial courts have to make sure somebody's been served before they enter a judgment against them?
That probably would be that type of situation. In this case, that's not an issue again. And the fraudulent transfers are just additional fraudulent transfers that were made during the pendency of that complaint between the same two parties. And so I think that's a different situation. I think in this case, there was no obligation upon the court, but even if there was, the court would have looked at the complaint and realized these are the same individuals. We have we have transfers being made while the preceding supplementary were pending for several years. 4 more transfers, not 1, but 4 transfers made while that complaint is pending against these 2 individuals. 4 more transfers that they've engaged in. And I think under those facts, any judge would have been well within their rights to determine that that was sufficient, especially when it's uncontested. The defendants have not come forth and said, you know, the pleading, we've been prejudiced, or we're unfair surprise, or anything like that. No assertions to that effect, that we can't defend, that you know, this is a violation of due process. There were no allegations like that were made in the trial court.
What if instead of an uncontested posture that the Thackers, if I'm saying that correctly, what if they did timely file an opposition that raised the issue of these fraudulent transfers that are addressed in these alleged fraudulent transfers addressed in the summary judgment motion are not the same ones that are alleged in the fraudulent transfer complaint? In other words, the preceding supplementary authorized the filing of a fraudulent transfer complaint, but it requires the filing of a complaint, and the rules of pleading generally disallow you to get summary judgment on something that hasn't been pleaded. And so when I look at counts 11 and 12 of your fraudulent transfer complaint, they talk about these disguised wages that, as I understand it, some company controlled by Mr. Thacker, instead of paying him the wages that he's owed, he directed them to be paid to Mrs. Thacker instead. But the summary judgment addresses completely different fraudulent transfers. They don't fit that disguised wages theory at all. So why doesn't your summary judgment motion have to match the pleadings or the allegations of the complaint in the fraudulent transfer context, where I think they would in any other context?
Well, in this case, there was no objection made to the pleading in the sense that it.
But assume that issue was raised timely and effectively in the trial court.
Had it been raised, that issue could have been litigated. And in fact, the plaintiffs could have possibly even made a motion to amend their pleadings at that point. But the point is, as you note, they didn't raise it. And so the issue couldn't be litigated. Furthermore, we cite cases in our answer brief, the Excelicet case, which is not responded to in the reply brief, which says that in proceeding supplementary, the standard is fair notice. Did a party have fair notice and an opportunity to be heard? And that's what's required in proceeding supplementary under Chapter 56. And under that standard, and that was a 5th DCA case that the Florida Supreme Court approved, under that standard, in this case, the answer would have been, yes, they did have fair notice. They never said they didn't. At no point did they say we didn't have fair notice or this was unfair surprise, and nor could they, because they engaged in the transfers. It was between the 2 of them. So there was no real defense on the basis that, well, this is a surprise, we had no idea, we can't defend. They didn't raise all that because they couldn't, because they knew they had done these things while these proceeding supplementary were pending.
Counsel, have they filed a response saying we don't think these were pled? We think they're seeking relief, not pled in the complaint. At that point, could your client have, if to the extent they thought that was an issue, had they had notice of it before the summary judgment hearing, could they have moved to amend their pleadings to cover that?
Had the issue been properly brought before the trial court, that would have been an option, had the issue been properly brought, but it wasn't. They made one comment, the last sentence in their amended response was, it doesn't appear that these transfers have been pled. They didn't say they were prejudiced. They didn't say they had to be pled. They didn't say the law required them to be pled. They simply said, it doesn't appear that they've been pled. And on appeal, they've amplified on that. But before the trial court, they never said anything about, we have no idea what these are. We can't defend against these. This is a total surprise to us.
Was there anything about the procedural posture below at that point that would have prevented or made it difficult for you to move to amend? Had you had notice of that before the hearing? Were you still within the time frame where you could have moved to amend?
We would have needed probably leave of court to amend. And, you know, that would have been an issue that would have had to be brought up.
But was there anything about the case management schedule that would have prevented you from moving for leave to amend at that point?
Not that I'm aware of, but I can't say for sure. I don't know the answer to that question is. But the fact of the matter is, it wasn't necessary because they did not properly raise this issue. And had they raised it, they didn't have a leg to stand on. They couldn't allege the lack of fair notice, which is the standard. And I think the judge would have said, you know, had it properly been litigated below, that the trial judge would have concluded that this is not it's not a case of an absence of fair notice. You had fair notice. Therefore, this, you know, the complaint is sufficient to alert you to the fact that you are engaging in fraudulent transfers between the two of you designed to avoid the effects of satisfying the judgment. And under those circumstances, I think the court would have been well within its right to allow the case to proceed the way it was. But again,
Counsel, if I may, when I had initially asked you questions about the new rule and the fact that the new rule states that the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact and that the movement is entitled to judgment as a matter of law. And my question was, you know, does this rule survive? Does the business court procedure rule survive the fact that we're now under 1.510, which specifically says the court has to state reasons on the record, which could either be written or on the record, I guess, orally, as to the basis for the summary judgment? And Judge Mize asked an interesting question. He said that, you know, what if parties stipulate? What if they stipulate to the entry of a summary judgment motion? And it appears that you would agree that they could stipulate. Under the business court procedure, it specifically states in 5.13, which everybody knows going into business court, that they're under the rules of the business court procedure. And so you've got this third sentence in 5.13 that says, failure to timely file a memorandum in opposition to a motion may result in the pending motion being considered and decided as an uncontested motion. So could we, as a panel here, in looking at this, could we say that effectively, that if somebody's in business court and they don't file a timely response, that it's essentially like they're waiving it. It's almost like they're stipulating to it. It kind of falls in that category. So now the court could just say, well, it's undisputed. And if a party now on appeal tries to raise the issue of 1.510A and say, hey, look, court, you should have put this reason and this reason and this reason in there, that the court could say, well, no, I didn't have to, because I was able to treat it like this was uncontested, like you all were just stipulating to this. Is that a way that we could read this and have it survive under 1.510, the new version?
I think it is. I think the rule gives the court discretion, and the court in this case used that discretion in determining that it was uncontested. So I think under those circumstances, I think we do effectively have a stipulated judgment. It's not an affirmative stipulation, but it's about as close as you can get when it's not contested.
Counsel, has anybody in this case asked us to strike down any provision of the Ninth Circuit Business Court procedures?
No.
Has that been relief requested by any party?
No, Your Honor.
Has any party made a legal argument that any provision of the Ninth Circuit Business procedures are invalid and subject to being stricken by us?
There's been no request for them procedures to be stricken. I believe the Thackers do say that the provisions are in conflict with the summary judgment rule, but they don't ask that they be stricken or be disturbed in any way. And I don't see them as being in conflict. I think in this case, the rule required within 30 days a response, and they didn't do it. And both judges, Beamer and Jordan, both determined that that rendered it uncontested. So I think
Do they,
that-
but counsel, would they, is there some requirement that your opposing counsel's appellate brief had to somehow move to strike the local rule? Is that, I mean, it appears on page 28 of the initial brief for the first case, 1545, that they do make that argument. They say that, you know, if we interpret the local rules to not require that the reasoning be in the judgment, that such local rules would be inconsistent with Florida rules of civil procedure and consequently invalid, and they cite a case to that effect. So are you aware that in order for them to challenge the local rule, that they would have had to file some separate motion or do some separate action against the Ninth Circuit itself?
I don't know if they'd have to file a motion, but I think that they should certainly argue that the rule is invalid and must be, you know, stricken insofar as summary judgment is concerned. I don't think that they do that in their brief. Again, you know, this is a culmination of 10 years of litigation. When this was argued back in the 5th DCA in 2017, you know, I don't think any of us ever thought we'd be here in 2025, attempting to satisfy the judgments that were entered, you know, back then. Yeah, I think we're getting to the point now where even the business court in Orange County, which has been struggling with these proceedings, massive amounts of litigation that have been filed over the past 10 years, trying to get these judgments satisfied under proceeding supplementary. I think, you know, the judges have come to the realization that there are not, you know, when there's not compliance with the rules, that it's, you know, time to enter judgment and move this thing along. It's been there for long enough. I will also point out that Mr. Thacker makes an argument, just to touch on this, about the entry of a judgment against him. The final judgment, summary judgment, was entered against both appellants, Mr. Thacker and his wife. And they argue that that's improper. Well, Mr. Thacker was not only this involved a fraudulent transfer, but he was a fraudulent transferor and a transferee, as we point out in our brief, because the checks were transferred from him personally to an account that he and his wife jointly owned. So in making those transfers from himself, he made them to an account that he still had an ownership interest in. So under those circumstances, case law that the Thackers cite, and they cite an 11th Circuit case, the SE Properties case, and they say, well, there's no authority for entering a fraudulent judgment against a fraudulent transferor and a transferee, only the transferee. Well, there's two state appellate court decisions, McCullough and Hansard, that say that that's not correct, that you can enter a judgment against a fraudulent transferor and a fraudulent transferee. And this is the precise type of situation that I think was considered, where the transferor, Mr. Thacker, retains an ownership interest when he takes property that he owns and then transfers it to an account that he retains an ownership interest in. And I think the judgment against him is important because it alerts the account holder, or account custodian, the account custodian, to the fact that it encompasses both Thackers, both joint account owners, so that there's no doubt that both joint account owners are encompassed within the scope of the judgment.
Can you address the double recovery argument?
Well, I think that relates to the double recovery. They argue it's a redundant judgment, and it's not a redundant judgment for that very reason, that it's necessary in order to make sure that the account custodian is aware that both owners of the joint account, their rights have been adjudicated.
Isn't it more fundamental than that? So, I mean, like anytime you get proceeding supplementary, the creating supplementary are meant to satisfy an original judgment. So even if the preceding supplementary judgment had been only against Ms. Thakkar, or Mrs. Thakkar, that still would have been an extra judgment, but it's not double recovery because it goes to satisfy the original judgment, right? The original judgment's for $2.5 million and $12.5 million, so, $15 million. If somebody gets an $800,000 judgment against the wife, or the two of them together, they don't get an additional $800,000. That goes to satisfy the original judgment, no matter who the supplemental judgment is against, right?
Right. It satisfies the 2017 judgments that were affirmed on appeal.
Is there anything on the record that tells us how much of these judgments have been collected?
Not that I'm aware of. And this record is almost 50,000 pages, and I'm not aware of any document that says how much has been, but I do know that it's far from the amount, especially considering the interest that's been running on these judgments since they were entered in 2014. But they are far from being satisfied. Okay, thank you very much for your time and interest.
Thank you, counsel.
I'll begin by quickly suggesting that a mistaken view, or the view that trial counsel probably had in this case of the business court procedures, was that based on the rule of civil procedure, which said at the time that you could file opposition materials with at least 2 days before the hearing, that allowed something to be filed 3 days before the hearing. And that's how we got where we are. And so an opposition was filed 3 days before the hearing. The business court procedures should be read in a way that doesn't create conflict with the rule of civil procedure. And that would be done by saying that you read 5.5 to mean that the decision will be made based on written materials and the arguments.
Even the rules of civil procedure contain a requirement on their own to identify the evidence upon which you rely. And, in this case, the evidence upon which I assume you're currently relying would be the same evidence that the movement relied on, which is like the checks, right? You wanted to say the checks, look at the date, they were signed after this. Is there any requirement or is there any law that if you're relying on the same evidence as the movement, you don't have to identify your evidence? Is it deemed, because the rules say, that, not the business court procedures, the rules of civil procedure say you had to identify the evidence you were going to rely on at the hearing. And your response did not, right? Even the one filed. Now at the hearing, they showed up and said, hey, look, these checks are dated later. It seems like they were dated later. Did your client need to identify the checks?
I don't think so, and I don't think anyone interpreted it that way at the time. The hearing was held, the argument was made at the hearing that this was different from what was pled, and a series of other arguments which we've raised as well were made, and all that was handled at the hearing. There was not...
Is there any law that says, this is a genuine question, I don't know the answer, I looked, I didn't find any, that if you're relying on the same evidence as the movement, you do not need to identify the evidence on your own?
I'm not aware of that, Your Honor, sort of going either way.
Okay.
I think what happened here was counsel appeared in good faith at the hearing. Counsel believed the motion was contested. Arguments were made at the hearing that fleshed these
But
things
you
out.
agree, even the rules of civil procedure said you must, the non-movement, your client, must identify their evidence to be relied on at the hearing a certain amount of time in advance, correct?
The current version does, but that came into effect after this hearing had been held. So yes.
And counsel, I know we're over time a little bit here. I did want to give you a chance to respond to the same thought question I think that was given to your opposing counsel, which is under the new Rule 1.510, where we've got this requirement that the court has to state on the record and find as a matter of law that a party is entitled to summary judgment. Could parties stipulate to a summary judgment, and in that summary judgment, it just says this is stipulated to by the parties or this is uncontested by the opposing party, and that's the basis? Under the new rule, could a court put their pen and ink, sign at the bottom of that summary judgment, and the only basis in there is the parties have stipulated to this, it's uncontested? Is that possible under the new rules or not?
be very careful how I answer this. Parties, if they did that, would be acting inconsistent with the rule, but because both parties agreed to it, it wouldn't be reviewable. The case law is quite clear that if you've invited error, then you can't become the basis of any sort
Waiver,
of
invited
review.
error. But isn't that effectively what we have here, where you've got a business court procedure rule that says that a trial court can consider it uncontested if there's no response? If everybody's in the business court and the business court rule says that, and you don't file anything in response, aren't you effectively tacitly telling the court, it's okay, judge, you can enter this as uncontested, because we all understand when we walked into this business court, that was the rule, that if we didn't say anything, that we're waiving it, we're stipulating to it, and therefore it's not reviewable on appeal, we're okay with it.
Absolutely not.
Okay.
The law and stipulations are that they must be narrowly read and must be clear. And here, we had a rule of civil procedure that allowed for filings up to 2 business days before the hearing. We have what I'll suggest are, at worst, ambiguities in the business court procedures of Orange County, or of the Ninth Circuit. And we had absolute efforts to contest this motion. And so ultimately, none of these circumstances could be read to be a stipulation.
Would it have been
This
different
is
if it was a
uncontested.
case management order? Like, what if this wasn't the local procedures? What if, and the Supreme Court's recognized trial judges can enter case management orders altering the deadlines under the Florida Rules of Civil Procedure? What if there was just a case management order that said, here's the deadline to file summary judgments, responses are due within 30 days, and failure to file a response will result in the court taking it as waived? Could the court do that by order?
I think that would be inconsistent with the rule.
So trial courts are prohibited from setting a deadline to respond to a motion?
With the summary judgment rule. So I think summary judgment requires these procedures to be followed.
Okay. Counsel, thank you so much.
Thank you, Your Honor.
Okay, that'll conclude our hearing. Thank you.
Please remain in your seat for the